All right, everyone. My name is Hunter Harbold, and I am going to be lecturing in our EMT lecture series. This is over Chapter 3, Medical, Legal, and Ethical Issues. If you need to contact us, you can contact us at education@pchdtx.org. So let's get started. This is coming out of the Advanced EMT book. It's okay if you're in a regular EMT class. We know it's fine. It's just a little bit additional information. It will not help you. It will likely help you. There's really not a big difference between the two books. Now, this is kind of a foundation of medicine that we want to do no harm. And with that, I'll say you also want to do no harm, right? So this is kind of like us in our education phase. We have to know what harm is in order to not do harm. So that's something to kind of keep in mind as like a guiding principle working through medical ethics and working as an EMT or paramedic or whatever field of healthcare you're ultimately going to end up in, is that you do not want to cause harm to a patient. And sometimes, in order not to cause harm, we don't make interventions. So sometimes we cause harm by doing too many interventions, but we can also cause harm by not doing interventions. So just keep that in mind. As a general rule, when you're going through an ethical questions, you have to ask yourself, well, what would be the best thing to do for this patient if this were for me or for my loved one? What would I want? And usually that can guide us through picking the right answer. Okay. Now, litigation, as in like lawsuits, that's what litigation means. It's increasing exponentially, right? The United States of America is a very, very litigious society. We sue people a lot for a lot of weird things. Some cases are really valuable and important, some aren't. So you just need to know that there is a lot of litigation that occurs in healthcare, and EMS is not exempt from that as a whole. We see that quite often. Now, I will separate these two words because students get these confused, right? Civil versus criminal, okay? So civil lawsuit is like when you think civil lawsuit, I want you to think like Judge Judy, right? So, this is where people can have like rental disagreements or divorce or family issues or, a malpractice lawsuit where you call or a negligence lawsuit or something to that effect on the civil side. So civil quite literally I want you to think money. For our intents and purposes, civil means money. And this is what you'll see on most television dramas, right? With like Judge Joe Brown or Judge Judy, right? That's civil law, okay? As opposed to criminal law, this is where you see like prosecutors and defense attorneys, and this is where people go to jail, right? Where they pay fines. So there is a little bit of a monetary side to criminal law, but it's a lot smaller, okay? Now, criminal lawsuits, negligence can be both civil and criminal in nature, and like assault and kidnapping and battery and murder, right? Those are all criminal acts, so they break criminal code, and usually you end up with jail and then prison time. So one thing to say is these are not dichotomous, right? That you could, I would just use negligence as an example. If you engage in criminal negligence, you're probably going to do some jail time, but you're also, once you get convicted on one of those, you're going to end up paying civilly, right? So you can be sued criminally and lose and do jail or prison time. And then consequently, you're probably going to get civilly sued as well. You see this a lot in like law enforcement, uh, say a police officer shoots someone that wasn't supposed to be shot or whatever. They could end up doing jail time for that act, but then the city and their insurance companies and the defendants themselves, like the police officers, they're all going to get sued civilly as well for money. So what you see in civil lawsuits a lot of times is they will name everyone and their dog, and whoever can pay will pay. So that's what you see in medicine a lot, I should say. But do know the distinction between those two. It's occasionally tested. Now, you can be sued for. I just can't stress this enough. Unfortunately, America is very litigious, so you can be sued for a variety of reasons. So again, do no harm. Do what the golden rule: do to others as you would want done to you, right? And a general rule that I think holds me to a higher standard is like, what would I want for my grandma or my mother or my grandpa or whatever, my brother. So you might want to think through those lenses to try to find the best answer for an ethical issue and try to put yourself in the patient's shoes or in a family member's shoes and think, well, what would I want if I were them, right? We call that empathy. So just be aware. I think that's a good guiding practice in EMS, especially on exams. and out in the field, of course. So we have this thing in EMS called the scope of practice. And, basically what this does is this, if I'm drawing a scope here, right, this determines what is all in there. So, you might have using a BVM and a splint, right? And, bandaging, right? But outside of that, if you start doing surgical airways as an EMT, right, you are outside of the scope of that. So you are no longer, you weren't supposed to be doing that. So you're out of your scope of practice, okay? So just be aware the scope of practice, it varies by state to state. Like California, for example, each county will have a set scope of practice for their providers. In Texas, it's really up to the medical director, who's the physician who oversees the EMS agency and tells them what they can and can't do. But just be aware that varies a lot state to state. So it's not hugely tested on the national registry, because keep in mind the national registry exam is a national exam, not a state exam. So the medical director, they'll have these things called protocols and standing orders, and I put that here for y'all. So the medical director, again, this is a physician. They can authorize EMTs and paramedics to do their care, and there's two different ways that we see this. Okay, a common way is online medical control. So this is going to be by the telephone or by the radio or by an app or telemedicine or some type of effect where you are online with a doctor and he's telling you what you should or shouldn't do. That is online medical control. It makes sense. You kind of have to use the internet or the phone or something like that to do this. As opposed to, offline medical control, these are your standing orders and protocols. So when you go on your clinical write-outs, you're going to see that every ambulance has an actual book, like a binder with printed pages of what do you do when you have a cardiac arrest or a hemorrhage or respiratory failure or anaphylaxis or whatever. Those are all dictated in standing orders and protocols. Now, what you see a lot is a lot of departments will start with, you start with your protocol, your standing order protocols. And then if you need help or if you need to do something that's a little bit more invasive, say you want to give epinephrine or give Benadryl or something like that, then you need to call a physician. So there is overlap between these two. Again, just like civil and criminal court, they're not completely dichotomous, right? Like there is overlap in those, okay? Now, again, going outside of your scope of practice, that could be considered negligence. Okay, we're going to talk about the elements of negligence that's very heavily tested. And it can also be a criminal offense. So, for example, again, as an EMT, if you decide to take your pocket knife and a ballpoint pen and start, performing a surgical airway in the Chili's parking lot for someone who's choking, you're acting in negligence. And that could be not just civil, they're going to take your money, right? They're going to sue you, but you could also be criminally prosecuted for that. So just be aware that different forms of this exist, and it's occasionally tested. All right. So these standards of care, right? So this work, and by the way, I hate reading off the slides to you guys. I'm not trying to read the book to you, but it's what we got to do to get through some of these more definition heavy chapters like legal and ethics. So excuse me if I'm reading off the slides, but I quite literally have to give examples on these. Okay. So the standards of care, this is how you behave, right? So this decides this is the proper standard of how an EMT or a physician or a nurse should behave. Okay, it's the standards that have been set. Really, these standards were set by generations prior to you, and that's a pretty sacred privilege that you're handed to upon entering this field. Is think of all the decades of generations of EMTs before you that have created this trust and privilege that our patients have, that they believe in us, right? They trust us to know their medical problems, and they will quite literally hand you their most sacred possession, right? Their child who is not breathing, and trust that you are trained and you know how to do that, and take care of them. So that is the standards of care, okay? So I'll just read this. You must be concerned about safety and welfare of others when your behavior has potential to cause harm, right? So, if you're being a jerk to a patient, right, or you're making them uncomfortable or something to that effect, that would be violating the standards of care that have been set by generations prior to you entering EMS. Now, this is established by medical research, of course, local customs law. They do mention this thing called EMTALA, right? It's the Emergency Medical Treatment and Active Labor Act. You'll see this in most Medicare, Medicaid funded emergency rooms. It doesn't always apply to freestandings, but it's basically, you'll see the sign when you walk in, right? And it says it's the law. I'm going to read this to you because it makes sense what it is. All right, if you're having a medical emergency or if you're in labor, you have the right to receive within the capabilities of this hospital, staff, and facilities an appropriate medical screening exam and necessary stabilizing treatment, including treatment for an unborn child. So basically, this law is saying that if you go to an emergency room, that they have to treat you, they have to assess you first and screen you, and then if necessary, they'll provide stabilizing treatment, and then they'll end up transferring you out usually. So this is the law, right? And it's EMTALA. It's tested occasionally. So how this will show up on exams, they'll say, what's the law that requires an assessment and stabilization of a pregnant female or of a trauma patient in an emergency room, right? The answer is EMTALA. Okay, EMTALA, you got to know that word. It comes up occasionally. Now, there's different standards too that determine what our standards of care are. Like the American Heart Association, the CPR standards, these change every about 4 years. They'll come up with a new upgrade, whether, hey, chest compressions used to be 100, now they're 100 to 120. Or, we used to do this and now we do, tourniquets is another example. Oh, we used to do this without tourniquets, now we do that. So just be aware, these standards are living, right? They're not just plopped in your lap and they never change, so we have to be able to adapt to that. And EMS does a really good job adapting in general, but just be aware of that. Also, state regulatory agencies, right, like the Texas Department of State Health Services, they can send out mandates and say, hey, we're not letting you do this anymore. Or, I'll give you an example. Uh, we have this tool as paramedics called capnography, which measures carbon dioxide. It's extremely expensive to do it, right? But basically, they said if you're going to intubate, as in stick a tube down someone's throat, you now have to have this tool that verifies the tube is in the right place. And that's basically a state regulatory agency that's coming down and saying, hey, a best practice, a standard of care is that if you're going to do this, you have to have this capability. That is a standard of care. Okay. So yeah, textbooks, and I'm not going to keep reading this to you, but basically standards of care vary, and they're decided by a lot of different places. Okay. Now, this is hugely tested, and it's talking about negligence. Okay. So negligence, the textbook definition, right, is failure to provide the same care that person with similar training would provide. Like you literally need to know that. Negligence is you're not doing the same thing that someone else with similar training would do. Okay? So I'll give you an example. It would be negligent as an EMT to not apply a tourniquet to someone who is gushing blood across the post office, right? When a regularly trained EMT would identify as a life-threatening bleeding and they would apply a tourniquet. So me, by not doing that and the patient, having a bad outcome, that would be negligence. Okay, so you're behaving negligently. Now, negligence has both a civil, as in money, and a criminal, as in jail time, component to it. It can be both. Okay, so do keep that in mind. This can get EMTs up in flip flops and orange jumpsuits. So you got to be careful with these. Now, there's this thing called gross negligence. So gross really means like big, okay, in the like big picture type stuff. Like gross anatomy means like big picture type stuff. So gross negligence, conduct that constitutes a willful or reckless disregard for a duty. So gross negligence would be like you trying to perform a surgical cricothyrotomy airway in the Chili's parking lot when you're only trained as an EMT, right? That is gross negligence. You are acting grossly out of line. So that's what gross negligence means. It's tested. You do need to know that, okay, and know some examples. So these are reckless, right? These are the ones that are like, what in the world were they thinking by doing that, right? Reckless behavior, okay? Just totally unexcusable. Why in the world would you ever do something like that? This is like, I don't want to keep giving gross negligence examples, but that gross negligence is the worst form of negligence, and it's willful, by the way, right? So this is when you're choosing to be reckless. Okay, very dangerous when this happens, and I agree there should be civil and criminal penalties for people that choose to be reckless, especially in regards of patient care. Now, moving forward, they will most definitely test these three words. Okay, and you may be wondering why do I keep telling you they're going to test this? Well, first off, on your national registry exam, the exam you take to get your national registry license, I looked it up. 10 to 14% of that exam is over EMS operations. So what does that mean? If it's a 120-ish question exam, you're gonna get a good chunk of questions over this type of material. So don't think, oh, I'll never see this. No, these are the questions that'll get you the points, on your exam. So just be aware of that, okay? Now, back on track, talking about malfeasance, okay? So first off, I want you to know a word. Feasance means to do or to act, okay? So it's like to do something. So mal means bad act, okay? Kind of like mal means bad. Feasance means, to act or to do. So a bad act or to do, right, malfeasance occurs if you perform an act that you were never authorized to do, such as a medical intervention that is outside of your scope of practice. Malfeasance occurs if you perform an act that is you were never. Oh, and I repeated that twice. Excuse me. So here's the deal. Malfeasance would be the classic that I keep telling you: Chili's parking lot surgical cricothyrotomy procedure that an EMT is performing. You're not trained to do that. Okay, so that's outside of your scope of practice. That is malfeasance. Okay. Now, moving forward to misfeasance, right? And sometimes I've heard these called, we won't go into that, misfeasance, right? So it occurs if you perform an act that you are legally permitted to do, but you do it improperly, right? So I kind of like to think of this one as you kind of like miss the mark, right? You kind of put on a tourniquet, but you didn't tighten the windlass, right? Or you didn't put it on tight enough, or something like that. You didn't. It's still negligent because you didn't tighten the windlass like a properly trained and normal EMT would do. So it's still negligent, but you did an act, you just didn't do it properly. You kind of missed the mark. That's misfeasance, right? So basically, that's misfeasance. And again, if you don't know, the word bad in Spanish means mal. Okay, so these are Latin terms, but mal means like, ooh, that's bad, right? Like that's bad. We shouldn't be criking people in the Chili's parking lot, right? And then misfeasance means, they tried, but they kind of missed the mark, okay? And then if we break down this word, non-feasance, right? It means if you fail to perform an act that you were required or expected to perform. So basically, this is like someone who's in cardiac arrest and you're on duty and you decide, nah, not today. We're not going to do CPR, right? You didn't act, okay? So that's non-feasance, right? So non means like you didn't do it, or did not, right? You didn't do it. So those are examples that I can give you, and I will tell you these do show up on quizzes and exams. So make sure you know these. I know they sound annoying, but it's just Latin. So if you break down the words, they're pretty easy. Now, moving forward, on negligence, this is tested often, right? You have to have all four of these following elements to prove negligence in a court of law, right? So civilly or criminally, you have to have these elements to be successfully prosecuted or found guilty. These are the things they're going to go looking for when you're on the stand, when you're in court. So the first one is duty, right? Breach of duty, damages, and proximate cause. So let's talk about these. So basically, you have a duty when you're on duty to act. Okay, so it's to act within consistent of the standards of care. Okay, so you have a duty to act when you are being paid or volunteering, like for your EMS agency, whatever, to act. Okay, so the minute that you decide to hop in an ambulance or a fire truck and respond to a call, you have a duty to act. Okay, that is what you're doing. Now, duty doesn't necessarily apply to us off duty. It depends, it varies state to state, but I'll give you, for example, in Texas, it doesn't apply, but that's not going to be tested. I'm just giving you a little tidbit you probably don't need. But so duty, right? It's the duty to act. You have a duty. You have a job. You're responsible. You're on duty. Okay, think of it that way. Now, a breach of duty is when a breach of duty is when you do not act within an expected and reasonable standard of care. So again, taking the Chili's parking lot thing, right? If you decide, to crike someone in the Chili's parking lot, right? That is outside of the standards of care of an EMT, so you're going to get in trouble for that. Now, the third one, this one's probably the more important one, is damages, right? So there has to be damage to the patient, and these can be both physical, right? So you can slice their neck open and leave them permanent scarring, or where they can never speak again. You damage their vocal cords or something to that effect, right? That would be a damage. Now, that's physical damage. And psychological damage, right? This is mental. So this could be like pain and suffering, or doing without, or they're not able to walk again, and that's causing them depression or something to that effect. So Just be aware that damages aren't always physical and you can't always see them, right? Like a scar or not being able to walk, but they might be psychological and we can't see that. So, depression and anxiety and all those things that come with it. So, be aware that there is a distinction between those. And then lastly, proximate cause. So there must be a reasonable cause and effect. This is also often called causation. Okay, causation. So proximate cause, also known as causation, right? There must be a reasonable cause and effect relationship between the breach of duty and the damage suffered by the patient. So what? That sounds like a mouthful. I'll break it down. So there has to be a cause and effect, right? So the book gives a really good example of this, right? So if you pick someone up from a car wreck and you are putting them on the stretcher and you and your partner drop them, and then come to find out they have they get to the hospital and they now have a spinal injury, right? You, the patient, right, as the plaintiff, would have to prove, the plaintiff, as in the one who is suing you now, would have to prove that the cause of you dropping them is what caused their spinal injury and not the car wreck, right? So that is the whole cause and effect. That's causation, that's proximate cause, and you need to know that. This can be mitigated by good documentation if you ever find yourself in these situations of, documenting like, oh, the patient was, had no spinal complaints prior to being placed on the stretcher, or had spinal complaints prior to being placed on the stretcher. We dropped them and they still had the same spinal complaints. I'm not an attorney, I'm not giving you legal advice, but the book even mentions this. So I'm just letting you know, documentation can be your friend when you're trying to defend yourself up on a stand from a bloodthirsty Jim Adler attorney who's coming after you and all your money and your agency's money. So just be aware, documentation can really help you out on these. Now, that's negligence. You definitely got to know that shows up all the time on exams, especially the National Registry. They love it. Okay. Moving forward, there's this term called abandonment. So, abandonment essentially means to leave someone. Okay. So, if you abandon a child, you think, oh, all right, you're leaving the child. But we can do abandonment as healthcare professionals, and really it means you're terminating their care without their consent. So, basically okay, when you start responding to a call, right, your dispatcher could say, nope, you're no longer going to the no lights and sirens response fall, you're now going to the priority one hanging, right? That's not abandonment. Now what is an abandonment is you're responding to a priority, one fall, or you're responding to a fall. You get there, you see, oh, this patient has fallen, we're trying to pick them up, and then neighbors come banging on the door and say, hey, 2 blocks down, my child just got burnt and they're severely burned. What do you do, right? The answer is you would have to call for help. Okay, you can't leave the original fall patient there, even though they definitely have a lower priority, they're not as sick. You would have to wait until someone with similar level of training as you arrives on scene and assumes patient care. So you might have to wait for another ambulance to arrive or a fire department who also has EMTs to arrive. Say, hey, I got the fall patient. Now we're going to send this ambulance over to the burn child. That's a classic example of not doing abandonment. What would be abandonment is, again, you arrive on scene to this fall. Someone comes banging on the door saying, we saw the flashing lights of your ambulance. My child's been burnt 2 blocks down. Please help me. And you just get up and go and leave. Okay? You can't do that. That is abandonment. So this happens a lot on wrecks too. I'll give you an example of what's not abandonment. So let's say you arrive on a 3-car wreck, okay, and you're triaging patients. You see one patient is barely breathing, or let me start. You arrive on scene of a wreck. You see a patient that is you know so they're complaining of arm pain, and then you go to the other vehicle. You see this patient has an amputated arm, and you go to the third car and you see this patient's not breathing. By you moving from car to car, that's not abandonment. You haven't left the scene. You haven't went to another call. You're still on the same scene. So just be aware that's not abandonment. Occasionally that'll be tested. Now, what would be abandonment is, again, you arrive on scene and then you're told, oh, a mile down the road, there's a whole nother separate incident, and you just get up and go, and you go to that other call without someone being on scene, assuming care of the initial patients. That is abandonment. All right, you can't do that. So those are several examples. This is tested quite often. So just be aware. Now, abandonment is a legal issue, right? And it's really ethical too. So you could get civil action taken against you, right? Remember, civil means money, like Judge Judy. So just be aware. And I'll give you, your book goes into details on this, but abandonment can occur in the emergency department as well, just so you're aware. Fun fact. So you can't just drop a patient at the emergency room door and drive off, right? There has to be an assumption of care. Someone has to assume care of that patient. If you don't do that, that could be considered abandonment. So when we drop off patients, we give a patient report, we give them demographics, you're required to leave a report, all these things that happen, that is the successful, what they will call handoff of a patient. You're handing the patient off to a nurse. I'll give you one more example of abandonment. It would be abandonment. Say you are a paramedic, okay, and I start an IV on a patient, okay, I'm a paramedic, I start an IV on a patient, and I say, you know what, I'm gonna go ahead and leave this patient to my EMT partner, and I'm gonna go drive, right? That is abandonment, okay, because an EMT doesn't know how to start and monitor IVs, and since I'm as a paramedic, I started it, and I just left my patient alone with an EMT in the back, that's abandonment. So why am I telling you this? Abandonment can occur even if you're leaving them with a healthcare provider, if they're a level lower than you. Okay. So, I can't, if I'm a paramedic, I can't just leave my patient with an EMT at the hospital. It has to be with like a nurse or another paramedic or a physician or something like that. So that's not commonly tested. That's more nitpicky, pedantic, but just be aware those are examples. Okay. Now, moving forward, assault and battery. So assault, it really doesn't have to be with touch. So I'll give you the definition, right? Assault is threatening or causing a person fear of immediate bodily harm without consent, right? So I could assault someone by raising my fist above my head, acting like I'm going to hit them, right? That could be considered assault. Now, battery is unlawfully touching of a person, okay? So this could basically be, I'm giving care to a patient without their consent. That could be considered battery. Now, I will tell you, some states really don't care. They don't differentiate the difference between assault and battery. They're just bound together as one penalty, okay? Like one law. But the National Registry does care. They want you to know the difference between assault and battery. They do care about this. So again, assault doesn't necessarily have to include you touching the patient, okay? So this could be, making someone think that I'm going to cause them harm. Again, like with a clenched fist above my head, acting like I'm going to slug them, right? That could be assault, okay? Battery is the unlawful touching, emphasis on there has to be touching that takes place in battery, okay? This is heavily tested, so be aware of that. Now, these can both be civil and criminal in nature. So again, civil, money, criminal, jail time, right? So that's supposed to be like a jail with someone in it. All right, moving forward. Kidnapping. So let me tell you, we know what kidnapping is, right? With seizing, confining, abducting, or carrying away by force. It does not have to be a kid, right? But the laws will still call it kidnapping. So basically, if you take someone against their will and like abduct them, right, that could be considered kidnapping. Obviously, this is a very serious crime, but it's not very commonly prosecuted in EMS. What is occasionally prosecuted in EMS is false imprisonment, right? So false imprisonment is confining a person against their will. Okay, so if you lock someone in the back of your ambulance, take them to the hospital, and they're a competent adult, and they're telling you, no, 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 I don't want to go, and they really have the right to refuse, right? And they've been informed, and you're doing it against their will, right? That is false imprisonment, okay? So be aware that false imprisonment, much more likely that you're going to see charges on that if you were to do something like that as opposed to kidnapping. I don't know. I've looked this up before, but I don't remember the answer if anyone's ever been charged with kidnapping in EMS. But the answer is probably not. But false imprisonment, yeah, people have been got in trouble for that before. So occasionally that's asked. Now, there is this thing, these are forms of defamation, right? Called defamation, and then there's underneath defamation is these things called slander and libel, and they want you to know the difference between these. But defamation is basically intentionally, emphasis on intentionally, making a false statement through written or verbal communication that injures a person's good name or reputation, okay? So to defame someone, right? To make them look bad. That's intentionally make someone look bad. That would be defamation. Now, there's two different forms of this, okay? The first one is libel, okay? And libel is something that is written, okay? So I can't stress enough that it's something that is written is libel, okay? So you're making a false statement about someone that's really bad, okay? So I could write, a blog post, about someone that tries to defame them, and that, you might be sued for libel. These are really hard to do, to prosecute successfully because of the First Amendment right, freedom of speech. But anyways, I'm just letting you know these can happen, okay, especially in healthcare. Now, the next one, which I put a little example down here, this is called slander, okay? So slander is something that you said, okay? Notice the S's, see what I did there? You like that? These are verbal statements, okay? So it's something that you said, and you can get sued for these. So if you basically are putting in a radio report and you're saying the patient is a smelly, stinky, rotten, toothless, cheese smelling whore, right? Not necessary to put that in your report, okay? You could be sued for that, okay? Because you damaged this person's reputation. Not only is that unethical and not cool, but I'm just telling you, that's something that you said, that's slander, okay? So if you slander someone, it's something that you said, and that's how this is usually tested. They'll give you an example like the one below, like a radio report where it's obviously something that you said. That would be slander. That is a form of defamation. Okay. Now, the Good Samaritan law. So basically, the Good Samaritan law, I'll tell you what it says in Texas. It basically says that if you treat someone in good faith without compensation, okay, without a duty to act, right? You basically cannot be sued for most reasons, okay? So basically, if you're doing the CPR or the Heimlich or mouth to mouth on a patient who's not breathing or something like that, they were applying a tourniquet. That patient can't come back and sue you because you were acting as a Good Samaritan. Now, the Good Samaritan law does not apply to you as an EMT. So if you're working as an EMT or even volunteering as an EMT, right, you have a duty to act, and you mess up, the Good Samaritan law is not going to protect you. And that's how this is tested, okay? So it's basically when you're giving good care, good emergency care in good faith, right, you won't be held liable for that, okay? So that's the example of this, and that's why that's tested. This varies from law to law, from state to state. And the reason they're saying it does not protect you from a lawsuit, it doesn't protect you as an EMT, especially when you're working. Okay. Now, I will say it does protect you, at least in the state of Texas, if you're off duty and you do like the CPR or tourniquet or the Heimlich maneuver. That's the maneuver we do if someone's choking. It does protect you in that case, but it doesn't protect you from like if you're working as an EMT, it will not protect you. Okay. Now there is this annoying. Well, it's not annoying. I don't want to put my opinion in here, but there's this thing called sovereign immunity. Okay, this is also called qualified immunity. And basically, what this says is it protects governmental agencies from lawsuits. So I'll give you an example. If I wreck an ambulance going 80 miles an hour and kill someone, um, everyone's going to get sued, but qualified and sovereign immunity, if I'm working for, like, let's say the Parker County Hospital District, they're usually pretty capped on what they will pay, because the reason this exists is you can't sue a hospital district or the city of Dallas for $1 billion, and now they can no longer do business because they're providing an essential service to the public. So that's kind of why these exist. These get really arguable and like use of force incidents and stuff like that. I'm not here to discuss that, but I'm just letting you know these are interchangeable terms. Qualified immunity means sovereign immunity. Basically, this is what protects governmental agencies of all sizes: federal government, local government, state government, special districts, right? This is what protects them from lawsuits. And if it doesn't outright fully protect them, it protects them by the monetary amount of which they can be sued. So they'll cap it at like $300,000. Like, I'll give you an example. Counties in Texas usually can't be sued for more than like $300,000. And again, it's so they can continue to provide services even if they get sued. So just be aware that exists. Now, consent. This is wildly high yield, and they like to get really pedantic on this and give you a lot of weird what if scenarios. So do pay close attention to this because this comes up often and this can get tricky. So basically, if I'm consenting to something, I'm agreeing to it. Okay. So in the case of emergency medicine, right? Consent is agreement to treatment. I'm agreeing to it. Okay. It's my permission. Yeah, go ahead and treat me. And it's required for pretty much everyone. Okay. Everyone has the right to a form of consent. Now, sometimes it's express consent versus implied consent. We're going to talk about that. But basically, you have to have consent from every responsive mentally competent adult before care can be started all the time. Okay, now how this happens varies and I'll explain it, but if the patient is alert, right, rational, capable of making informed decision, they have the right to not consent to care, which would be right, which would be refusal of care. They have the right to that. So a patient has the right to have a full blown heart attack. And if they're rational, alert, right, capable of making informed decisions, they have the right to say, I'm not going to the hospital by ambulance. That's their right, okay? Not a good decision, but there's not a law against being stupid or making bad decisions sometimes. So just be aware patients have the right to refuse care, and that's an important principle that you do see not only academically like in your exams, but you see this clinically a lot. It's very, very tricky. Now, consent requires decision making capacity, right? So we can do this by a variety of ways, right? We can determine, is the patient, do they know where they're at? Do they know what today is? Do they know who the president is? Do they know, what year it is? And, do they have a current understanding of the surroundings? Sometimes you'll even ask patients to do, I've seen them, they're like, oh, how many quarters are in a dollar? Stuff like that. You're basically trying to see, do they have decision making capacity? Okay. Again, you don't have to like it, their decision making capacity, but they have to have decision making capacity. Okay. Sometimes you'll hear people use this term, which I think is annoying, called ANO, right? Alert and oriented times four, right? Person, place, time, and event. Okay. So sometimes people will use that as a one single tool to determine decision making capacity. It's just a tool in your toolbox to determine if they have decision making capacity. Now, uh, talk to the patient to understand what is happening to them, and see in their own words. Can you explain this to me? You have to figure the if someone can explain, yes, I'm having a heart attack and I understand that this could kill me, but I don't want to go to the hospital by ambulance, I can't afford the bill or whatever, then they're showing that, yeah, they're making this decision and their rationale behind it. Okay. Now, there's various forms of consent. The most common form of consent is expressed consent. So if I'm expressing myself, I'm letting it speak, right? I'm speaking it, right? And the expression can come in the clothes you're wearing, right? Or the what you do, or the way you talk, or the way you smell, right? You're expressing yourself. But in medicine, it's really what you do is expressed consent, okay? So patients can acknowledge that they want your care or transport, and this can happen both verbally or non-verbally, right? So they might literally say, yes, I would like to be transported to the emergency department today by ambulance, right? That is verbal consent. It may not be as formal. They might just say, I want to go to Medical City, Weatherford. Okay, cool, right? They just said they want you to take them to Medical City, Weatherford. That's expressed consent. Now, it can be nonverbal too, and you see this a lot. So keep in mind, just because someone says they want to go to the hospital by ambulance doesn't mean that you have the right to take their vital signs. Every piece of medical care requires consent. Now, what will happen a lot is you'll inform the patient, informed consent, and they a lot of times like, hey, I would like to take your vital signs. Can I take your blood pressure? And they might non-verbally just stick out their arm and hold it to you like a straight arm to say, yes, here's my arm. Go ahead and put the cuff on. That's a nonverbal example, and they like to use that as an example a lot of times. That the patient that sticks out their arm for a blood pressure, what type of consent is this? That's expressed consent. They're expressing their will to do it. Yeah, it's a yes. Okay. Now you also have to provide informed consent. So you have to inform the patient of what you're doing, the risk of it, why you're doing it. This doesn't really become a huge issue for EMTs, but it does for paramedics. But you do have to inform them of why you're doing it. Okay. Patients have the right to refuse any part of your patient care if they are rational and of decision making capacity. Now, in order for express consent to take place, the patient has to be of legal age. In the United States, this really varies. So I'm just going to say it's usually around 17, 18, but usually 18 is the magic number. Um, and they have to be able to make a rational decision. Okay, so you know, it would be irrational if someone is, I give an example. Someone who's homicidal or suicidal, they're not rational, right? Someone wanting to kill themselves or others, not rational. So they don't get to make some decisions anymore. We have to treat them under implied consent. Next slide. And that's an example of someone who's not being rational. Okay. So they can agree to one part of the emergency care. So they might say, yes, I will let you take my blood pressure, but no, you may not listen to my lung sounds, right? That is their right. Okay, just be aware. It's tested. Now, implied consent, this is where you're implying, right? You're making an assumption that the patient would want you to do this. And the only time we get to use this is if like there are patients unresponsive or they're delusional or delirious or they have an altered mental status and they're not able to make an informed decision. Okay, so this is when we get to do that, and that's implied consent. Now, we use implied consent in a few other reasons, and I'll give them what they are. I'll give you the examples here in a minute, but implied consent's only limited to true emergency situations, right? So you can't use implied consent out of convenience. Oh, the patient's not telling me what I want to hear, so I'm just going to treat them underneath implied consent. No, right? That's not what this means. It's for emergencies, okay? Unresponsive, unconscious patients. We're treating them because we think that's what they would want if they were able to consent. Okay, so it's implied consent. So, you have to document this carefully and thoroughly with why you treated them under implied consent. You know, try to get consent from a spouse or a relative. This can be really helpful. I'll give you an example. You have an 82-year-old male. He has a urinary tract infection. He's extremely irritated and he's, cursing you out. But he thinks that aliens are chasing him, and he hasn't taken his medicine, and he doesn't know what today is, and he thinks that Jimmy Carter's the president. So he's obviously not of sound mind, and he needs to go to the hospital. We might have to treat him underneath implied consent, and he may not want to go to the hospital, but it really helps you if you can like have the wife or the daughter or the caregiver try to talk them into it, or at least get their consent, right? Hey, we really think he needs to go to the hospital. Is it okay if we take him? Yes, please take him. We'll meet you up there. That's a best practice per se. Now, um, so refusal of care may also be an implied right. Implied consent no longer applies if the patient becomes alert and appears capable. So I'll give you an example. Say someone has a seizure in Walmart and they're post-ictal, which means after a seizure they're really tired and usually a little altered, have an altered mental status. When they come to, so you start taking their vital signs when they're post-ictal and still altered, they can come to and say, hold on, I'm fully alert. I'm able to make decisions now. I want you to stop touching me. I do not want to go to the hospital. They have the right. So again, consent is dynamic and it's volatile, right? It changes, it moves. It's not just static. So just be aware of that. That patients they can go from implied consent back to expressed consent and say, nope, I don't want this anymore. So just be aware. Now, minors in consent, minors really don't have a say-so in not going to the hospital for the most part, okay? The parent or the legal guardian are the ones who give consent. And the reason is that the law doesn't really look at minors as like having decision-making capacity. So there are some exceptions to this, okay? Um, Basically, depending on the age, some states at 17 or 18 with where they're considered civilly an adult, okay? That doesn't really matter. But you could get a vignette where you have like a 16-year-old female who is pregnant and married was involved in a motor vehicle collision and does not want to go to the hospital, right? She could actually refuse because she's married, right? The example that she's married, pregnant, right? So if someone's pregnant, and then this last word, emancipated minors. So emancipated minors, someone who goes before a court and says, I want to be emancipated, right? So emancipation means to be freed of. So they're being freed of their parents and they're still a minor. And this is granted by a court, and that's an emancipated minor. This doesn't happen very often, but they have to be like financially stable and mature and able to make their own decisions. And that's an example of an emancipated minor. Now, here's where these get annoying. Is last time I checked, you're not carrying pregnancy tests in the back of your ambulance to be like, 16-year-old patient, you're telling me you're pregnant and you want to refuse my care. go ahead and urinate on this pregnancy test to prove you're pregnant. You know what I'm saying? Like, it's a really weird dynamic. Or them carrying their marriage license around with them, like, that's weird. So, or their emancipation papers even. So this becomes really difficult to do in emergency medicine, and you don't see this a whole lot, but you do see this academically. You'll get questions on this. So moving forward, you do want to provide consent. You want the minor to provide consent, at least informed consent when possible. Trust me, getting vital signs and taking care of a child who is allowing you to take care of them is a lot easier than a screaming child who does not want you to take care of them. So you still need to inform the patient. That's a best practice, okay? Now, there's this thing called in loco parentis, and this basically means like the teacher or a principal or a daycare worker can act as the parent or the legal guardian in absence of the parent or legal guardian and make medical decisions on the patient's behalf. You see this a lot. I've done like bus wrecks and stuff, and the bus driver would be in loco parentis in that case, right? So the bus gets in a wreck. The bus driver says, nope, no one's going to the hospital, no one's injured, and the bus driver's over there signing all your paperwork on the patient's behalf because the parents aren't there. So just be aware that exists. In loco parentis, and it sounds sophisticated. So involuntary consent, you really don't see this a lot, but basically, I want you to know this. It is an oxymoron, right? Because consent's really never involuntary, right? You're not, how do you like involuntarily agree to something? You know what I'm saying? Like, that's an oxymoron. But people under arrest or in prison do not lose the right to be involved in medical treatment decisions, and this is important. Someone in prison has the right to refuse care. They really do, if they're rational, right, and they have decision making capacity. So you can't. This becomes really sticky and a long discussion we're not going to get into today. But where you'll see this too is people get arrested, and the police officer will say, well, they're gonna get an IV. You got to, or they're gonna get this, or they're gonna get that. It gets really complicated and it varies state to state with what authority that police officer is acting under. But just be aware, involuntary consent. It's patients always have the right to consent, even if they're under arrest. Okay. Now, forcible restraint. This is a pretty rare thing that happens in EMS. I've only done this a handful of times, but it does happen. So basically, it's restraining someone. It's tying them down. That's physical restraint, or chemically. As paramedics, we can use chemical restraint. We can put people to sleep with like sleeping medication, if we need to. So just be aware that restraint is a really slippery slope, ethically and legally, because you're taking away someone's rights, like literally all of them at once. When you start restraining patients. So you need to have a good reason for doing this. It needs to be well documented. It needs to be observed by many. Like if you're restraining someone, it's not a bad idea to get law enforcement or someone with a body cam out there, and multiple agencies out there, because this is a big deal. You are taking away every one of someone's rights when you start restraining them. So don't make light of it, right? We don't restrain someone because they're being a pain in the ass, right? That's not what we do. We restrain someone because they're physically violent or they're posing a risk to others or themselves, right? And they're in need of treatment. That's when we restrain someone, not because they're mean mugging you, right? Not because they're saying naughty words. It's because they show a propensity to violence, or they're physically violent, or they're trying to hurt someone or themselves. So just be aware, words aren't usually enough to restrain someone. They need to actually be violent. So basically, if you believe the patient is a threat to themselves or others, we can restrain them. A lot of times you need to call medical control for this. That depends on your department. But if you restrain someone without their, without, the authority to do so, you're opening up the case for some civil and criminal penalties, some negligence per se, stuff like that. So if patient is responsive and situation is not urgent, you should really can try to get consent. Okay. Now, the right to refuse treatment. So alert, rational adults who appear to have decision-making capacity have the right to refuse treatment at any time. Okay. So let me give you an example. They can revoke their consent at any time. So you can be transporting in a 20-minute transport, and you're 10 minutes in. The patient says, "I want out." They can get out. Okay, if they're of decision making capacity, they can get out. Okay, that is their right to refuse care, and you don't have to agree with it. You don't even have to like it, but that is their right. So that's called patient autonomy, right? The patient has the right to make their own decisions. It's called patient autonomy. It's a buzzy word that you might want to know. It's in your book. Now, um, these calls are commonly litigated, so you need to proceed cautiously. This is where you really want to document extremely well and make sure you're crossing your T's, dotting your I's, given the necessary details, using direct quotes. You want to make sure that you're documenting well on these because these are often litigated. They go to court. That's what litigation means. Now, the right to refuse treatment. Make sure the patient understands the potential risk, benefits, treatments, and alternatives. Right. So basically, let's just say let's go back to the let's C collars. Oh, I love these C collars, right? A cervical collar. So the patient's like, nope, I don't want a C collar. So you need to explain like, okay, ma'am, I understand you don't want one, but there is a risk that you could have a spinal injury. We can't see that. This would hopefully lessen the risk of additional injury, and it would benefit you in that way. And if you don't take this cervical collar, you could have serious injury, including paralysis. Right. So we're explaining the potential risk and the benefits. There are other treatments like, may I recommend, a better size C collar or maybe, something or, holding your head still or something like that. I'm just spitballing here, but you could give them alternatives if there are any. Okay. And they have the right to pick and choose. Okay. That's their right. Now, in order for the patient to refuse, they have to be alert to person, place, time, and event. I get real hung up on this. Yes, they have to be. They should be. Yes, they should be ideally, but that's not it. Okay, a patient that's alert and oriented times four. This is what I was talking about earlier. The A and O times four thing. Just because they're alert and oriented times four, person, place, time, and event, doesn't necessarily mean they have decision making capacity. This is just one of the things you would use to determine I don't like this decision, but they are making a sound like they have decision making capacity. So just be aware, this is just one tool in your toolbox. Why do I keep hitting on this? Paramedics like die on this, and EMTs die on this hill and think, oh, they're A&O times four. I let them go play tag with a semi. No, okay. Well, this is a good example. Someone's A&O times four, but they're homicidal. They're suicidal, right? Doesn't mean that they have the right to refuse care. Doesn't mean they have decision making capacity. Okay? Most suicidal people are alert and oriented times four. So this is just one piece, okay, of the puzzle. So don't hang your hat on that. Don't die on that hill. Um, so of course you want to urge the patient to go. So I'll give you an example, like a car wreck or something like that. They don't have to, if they're adamant they don't want to go by ambulance, okay, well, I still recommend you're seen by a physician. You still should go to the hospital even if it's not by ambulance. If you change your mind at any point, please call us. We'll come right back. I always tell patients that. If you change your mind, call 911. We will come right back. It doesn't matter if we're 1 minute down the road or 2 days down the road. We will come right back. Okay. Now, state laws generally, for the most part, don't allow a parent or legal guardian to deny treatment for a minor for the most part. Now, let's say there's a minor wreck or something like that. Yeah, the parent can refuse care. Where this becomes bigger is in like regards of like it's not an EMT thing, but like blood transfusions and stuff like that. A parent doesn't have the right, like a Jehovah's Witness, doesn't have. If you don't know, Jehovah's Witness don't allow blood transfusions in their religion. A Jehovah's Witness doesn't have the right to say, nope, my daughter is not going to have a blood transfusion, even though that blood transfusion would save their life. They don't. They actually don't have the right to do that. So just be aware. That's kind of what they're saying. Okay. Now, um, if you are unable to obtain consent, you want to this is like documentation will be your friend. And you also want to have this witness, not just by your partner, but like by the fire department or by a police officer or by the family even, right? Okay, sir, you're seeing that your wife at this time has been informed of the risk of refusing to go to the hospital today by ambulance, and here's the risk associated with that, and here would be the benefits, and we still recommend that she's seen by a physician. And you're understanding all these risks. You're going to sign this form, and I'm going to ask you to witness that you saw me explaining this to her, and that you're witnessing her signing our refusal form, right? And this isn't even me being fancy. This happens like probably 9 times out of 10. You'll get family members to witness it. So just be aware, especially like high risk refusals. Like, what's a high risk refusal? People that are refusing, and you're like, oh God, this isn't a good idea. This is going to end up in court, right? That's a high risk refusal. Now, advanced directives, these are kind of complicated. Do know these show up a lot. So, An advanced directive is basically you're giving an order ahead of time, right? If you break down the word advanced directive, right, you're giving a directive, an order ahead of time. So basically, these are telling someone what to do if you are unable to make decisions. Okay. And these come in a lot of different flavors, and this is where they get confusing. Like a living will, or a power of attorney sometimes, or a do not resuscitate order, or an organ donation. Those are all forms of advanced directives. You're telling people what to do in advance. Okay. Um, so generally, in order for it to be valid, an advance directive, it generally must state the patient's medical problems, have a signature of a patient or guardian, and have at least one have a signature of at least one physician. I'll show you what these look like on the next slide. Um, like a DNR for. Let me just go back. Let me give you an example of each of these. A living will might be like, okay, I know I have pancreatic cancer, but I don't want to have any chest compressions done, but I will allow cardiac medications and AEDs to be used. Okay, that's a living will. That's an advanced directive. Okay, or a power of attorney, for example, is an attorney speaks on your behalf. Basically, that's when they act on your behalf. A power of attorney is, let's say that, okay, shall I not be able to make decisions on my own? A medical power of attorney for me would be my I'm just I don't let's just say my girlfriend, right? You could say I appoint my girlfriend person X to be my medical power of attorney, so where they can make my medical decisions. Shall I not be able to make decisions for myself? That's an example of a medical power of attorney. And then lastly, a do not resuscitate order. These vary state to state, but um, they basically say do not resuscitate this patient. These do not say do not treat this patient. So oxygen is a treatment, it's not resuscitation. So basically, like in Texas, a DNR order, a do not resuscitate order, looks like this. It's very blurry, but it has a little Texas up here, and there's two places that a physician has to sign. So there's two physicians that sign these and say, okay, this patient really does not want chest compressions and resuscitation. Shall they go into cardiac arrest? And these questions, I'll show you how DNR questions pop up. Is how DNR will pop up is they'll say, you're dispatched to a priority one cardiac arrest. You arrive on scene. The family is not doing CPR, and they greet you at the door with a valid copy signed by two physicians and the patient of a do not resuscitate order. What should you do? The answer is you do not resuscitate. Now let's give another example. You're dispatched to a priority one cardiac arrest. Family is not doing CPR. They greet you at the door and say they think the patient has a DNR, but they can't find it. What do? You do CPR. You do resuscitation. So you'll see questions occasionally where they'll be like, what do you do if the DNR isn't there, or it's not signed, or it's not valid, or they can't find it? The answer is you still resuscitate. So the only time that DNRs are valid is if they're signed and you are presented with them and they are valid. Okay? So just be aware, sometimes you'll get questions on that. Now, I was talking about a power of attorney. Sometimes these are called healthcare proxies, right? So this like a proxy is someone acting on your behalf. So like a durable power of attorney for healthcare, okay? And again, I can't stress enough, power of attorneys are only valid if the patient is not able to make decisions. I'll show you where this shows up in the real world. You have a patient, he is of decision-making capacity. You determine that he's learning times four, he's not homicidal, suicidal, and he does not want to go to the hospital. But the daughter shows up, and she is the patient's durable power of attorney, and she says, nope, I want him to go to the hospital. What do you do? Well, the patient is of decision making capacity, so he still gets to make his own decisions. Just because the patient's daughter has a power of attorney does not mean that she is his master at all times. She only gets to make those decisions when he cannot make decisions. So you'll see that clinically a lot. People with power of attorneys think that they're, God or something, and they get to make everyone's decisions. They don't. They only get to make decisions when the patient is not capable of making their own decisions. Okay? Moving forward, um, ethics. I'm not even going to read these to you. But ethics. It's basically right or wrong. Okay, and morals is our code of conduct. It's determined by our society. Okay, and applied ethics is how do we apply these into the workplace? How do we apply ethics as being a paramedic? Don't want to go into a lot into that, but do be aware we do run into a lot of ethical dilemmas. Okay, and I think it takes a lifetime to be to work on our ethics and our morality. Now, confidentiality, this basically means something that, or sometimes you'll be like, oh, we held this in confidence, or it's, something like that. It's basically saying it's kind of secret, okay? It's secretive. We don't want the whole world to know. It's confidential. Now, communications with patients, it's confidential. You could also say communications with patients, it's kind of secretive, okay? You don't go tell your rabbi about this. You don't tell the whole world about this, okay? You don't go talking about this at the gym with your homies. So this is something that you don't tell the whole world. Now, um, this is everything. You can't go talk. Oh, I ran this guy, and he had a beer bottle in his rectum, and we did this and this, and his name was this, right? You can't do that. Okay, you can't talk about that. You are held to an ethical, legal, moral standard to hold a patient's communication in confidence. Okay. If you release this information, you're liable, both criminally and civilly for that. So you can get in huge trouble for breaking this code. Uh, Generally, you can only release records if the patient signs a release asking for them to be released. If it's legally subpoenaed, right? So if a court says you got to give us these records, you got to give them the records. If you're sharing information with a third-party billing company, okay, that's reasonable. To health agencies concerning diseases that affect the population, like STDs or like contagious disease, like Ebola or tuberculosis, they have that has to get released to health agencies. It's an interest of public health. This gets hairy, but events such as seizure activity while someone's driving, the EMT really doesn't do that. That's more of a physician mediated action. But okay, in cases of rape or abuse, those can also you're, but let me say this: in that case, it's probably going to get subpoenaed. So just be aware. Now, uh, I can't recommend you this enough. Is try it in your best to to limit your subjective finding. Remember, subjective is like what we said, or what we see with our sight. Notice all the S's I'm throwing out. But objective is something that is black and white. Okay, the car, the the patient, was not wearing a shirt. Okay, that's black and white. The patient is or is not wearing a shirt. Or, now it would be subjective for me to say the patient smells like poop. You know what I'm saying? The patient has a bad attitude. That's my opinion. Okay, so that's you don't want to you try want not want to put stuff like that in there. What you could say that would be objective if you want to say the patient smells like poop. The patient has feces, stained to his pants, right? You might imply that they smell like poop at that point. So just be aware of that, okay? Just giving you an example. Now, this whole HIPAA thing, and you actually do need to know it's not spelled like hippopotamus, right? It's HIPAA. This is commonly misspelled, and it shows up on exams where they'll just say, which one of these? And they'll intentionally misspell it and spell it like this. That's wrong, okay? So make sure you know that it's spelled the right way, that it shows up sometimes. But this is the Health Insurance Portability and Accountability Act, okay? So there's more A's in this than P's. That's how you can know how it's the acronym. Um, the idea of this initially was to protect health information, but really to make it more exchangeable amongst healthcare providers and insurance companies. And it's kind of morphed into this whole patient privacy thing. So again, it would be breaking HIPAA and confidentiality if you were to go to the gym and start talking about, the guy that blew his head off in the Walmart parking lot. Okay, you can't talk about that. Okay, it's protected. You can't talk about those things. So there's criminal and civil penalties for that. And where we're seeing a lot of this is people are posting wild, ridiculous, nonsense garbage on social media. Don't be placing, I got into some Facebook fights on this. People will take a picture of the back of an ambulance after like a cardiac arrest and post it on freaking social media. First off, disgusting, tasteless, no ethics, no morals, uh, tacky, unprofessional, unbecoming of your profession, breaking confidentiality. And not only that, you look like a total goober, Rescue Randy. So don't be doing that, okay? Keep your job off of social media. Don't be posting wreck scenes and house fires and the ambulance after a cardiac arrest. It's unprofessional. Don't be doing that, okay? Now, what I'll also say is You can't go on there saying radical stuff and expect that not to get you in trouble at work. Most employers that involve healthcare, like I worked at hospitals before, they have social media policies. You can't go on there. Used to work at Cook Children's, for example. It's a pediatric emergency room in Fort Worth. And you can't go on there talking about your anti-vax beliefs working for a pediatric hospital. Okay, you can't do it. You get in trouble. You lose your job. So be aware. Yeah, you have free speech, but as they say with free speech, you can't yell fire in a crowded church or a crowded theater. The free speech does have its bounds. Okay. So basically, I hate the way they say this, but as far as records and reports, if it wasn't recorded, it didn't happen, right? Yeah, that you could say that, but basically what they're trying to get at is you need to document everything that happens. If your report sucks and it's untidy and incomplete, you're going to get massacred on the stand when you go to court on it, and an attorney is going to have a heyday with you. It's going to be too easy. So you want your report to be pretty airtight and pretty solid, so you don't end up getting in trouble on the stand. Okay, so make sure you are making good reports. Remember, reports and the records that you're making, your charts, those are kind of to help you if there were ever your care was ever questions, or if you ever went to court. It also helps with billing of what actually happened on this call. It also helps in the continuum of care. So good patient records and good patient reports aren't just convenient, they're required. Like, it really is a part of being a paramedic, and it's probably like half your job is charting and stuff, unfortunately, but that's the world we live in. You can thank our litigious society for that. Now, mandatory reporting requirements. I'm going to disagree with your book on one of these, but let's hit them. So I'm going to read these off for you. So you have to require mandatory reporting. Basically, is if you see this, you are required. It's mandatory for you to report it to the authorities. Whether the authorities be the public health department or law enforcement, that's a whole nother discussion. But um, it's mandatory to report child abuse or elder abuse. Yes, for sure, for sure, for sure. It's required to report that. Okay. Now, it's may it's not necessarily required to report domestic violence. Now, if you get the, I swear you are going to get this on an exam, and I'm going to be like, sorry, but I'll give you the classic example. If someone has marks around their neck consistent of choking, and they tell you, oh, it was my lover, and blah 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 blah, but I don't want them to go to jail. I don't want them to report. What you can do is try to ensure their safety, make sure they have a safety plan. But what you really can't break confidentiality on that. And I don't know why your book is saying you can, because you can't. So adults have the right to endure domestic violence. Like, I'm sorry, they just do. It's not my opinion. I don't like it, but it's the law. So this one's a little questionable. Not sure why your book put that in there. But anyways, moving forward, if someone's injured during the commission of a felony, so someone like, gets their arm blown off, like they present to the emergency room with their arm blown off, and you're like, hey, bro, how'd you get your arm blown off? And you find out, oh, they were robbing a bank, and that's why their arm got blown off. You know what I'm saying? Like, yeah, you can't do that. So that has to be reported. Drug related injuries, so usually overdoses will get a police report tied to them. Doesn't mean someone's going to jail, but at least a record of it. Childbirth, that has to be reported. Rape, animal bites, especially animal bites, those have to be reported. They always get a police report. It doesn't matter if it's an adult or a child. And certain communicable disease. This is what I was talking about, like tuberculosis or Ebola. Even like HIV and stuff. Those are communicable diseases that get reported, and they're tracked by public health, and those are mandatory reporting. Now, the scene of a crime. You want to make sure that you're not destroying the evidence. Okay, keep in mind car wrecks are a crime scene. I know you think they're benign and they're just like an everyday thing, but they are a crime scene. So just keep that in mind. You don't want to, there's this call that's ingrained in my mind. Basically, I went into this house. This lady had told her son to close the door. I'm going to kill myself. Well, she did. She shot herself in the head. Well, we get there, and I walk in the room, and I go up to her to confirm she's dead. And I hear a ping, like I stepped on the casing that was ejected from the gun that was still in her hand. And it shot it up underneath the dresser. And I was like, oh God. So anyways, just be aware with where you're stepping, and all these things. I will tell you something that's occasionally tested: a scene of a crime, evidence preservation becomes a thing. Typically, you want to put evidence in a brown paper bag or not a plastic bag, because it causes smearing. Um, so If death is obvious, you don't have to go up there and start yanking them off the bed and checking pulses. On this particular scene I just told you about, the lady that shot herself in the head, um, it wasn't particularly obvious with the way she was laying, so I really did have to go up and be like, "Oh wow, the other side of her head's missing. Yeah, we're done." Like once you determine they're dead, you can stop. Don't keep manipulating their body and touching. Um, so physical signs of death. We're getting towards the end. Hang with me. Basically, uh, death obviously is defined as circulatory and respiratory function has ceased, its absence of breathing and heartbeats. But if the body is warm and intact, we usually have to initiate medical care. The exceptions to this is, like yeah, I'm going to be weird, but if someone dies outside today and it's August, if someone dies outside today, uh, but they're like obviously dead and have lividity, which I'm going to show you what that looks like on the next slide, they could be warm and their body's fully intact, but they're definitely dead. Okay. So, as a general rule, though, if someone's body is intact and they're warm, they're not dead. Okay. Now, uh, presumptive signs of death are generally adequate, so especially after severe trauma or long-term illness. So I'll give you an example. So like someone who has been decapitated, as in their head's missing, it's pretty obvious that they're dead at that point. Okay. Someone who has been incinerated, they have been burnt alive, right? They are just a charcoal briquette in the bottom of the house, right? They're dead. Someone who I've had a guy who had a guardrail go through his chest, so I can see straight through his thorax. He's dead. Okay. So things like that, that's obvious death. Okay. So what you'll hear sometimes is a phrase called trauma unsustainable with life. Okay. Now, this thing, what they're showing here is lividity. And this is what I was talking about earlier. So basically, when we die, a patient dies, the blood will pool like a pee, like pool, like pooling of blood, and because the heart's no longer beating, and this follows gravity. So this patient died and was laying on their back; they were supine. So that's why blood has pooled to their back. Now, I've had patients that died and they were leaning forward, and the blood pooled in their face. I've had patients that died on their side, and all the blood is pooled on their side. I've had patients. People die in weird positions, and I want you to know that lividity happens. I don't know, like hours plus after death. So it's not, so that's how you know, like, oh, they're dead, dead. Like they're really dead because it's hours after they died. So, generally they won't have a carotid, if someone's dead, they won't have a carotid pulse, no eye movement, no blood pressure, cyanosis. They would have a lower body temp, okay? But definitive signs of death are decapitation, that's when someone's missing their head, dependent lividity, or this thing called rigor mortis. This is a very high yield term. Rigor mortis. Rigor mortis is stiffening of the muscles. It's decomposition of the muscle after death. So basically, probably like 45 minutes, maybe an hour, same thing, probably an hour to 8 hours after death. Someone can get rigor mortis, which is stiffening of the muscles after death. So the first place this sets in, which this will help you clinically, is in the jaw. Okay. So you could go up to someone, you're like, they don't have a pulse, and what I'll do is I'll go up and kind of shake hands with their jaw. I'll take their jaw and move it up and down. And if it's clenched shut and it's like stiff, they're dead. That's rigor mortis. So that's obvious death. We're not going to do CPR. We're not going to work them. But if it's like nice and loose, okay, they probably just died and you need to work them. So well, I'm just letting you know that this tends to set in first in the jaw. It's one of the, and it's not my opinion. This is in the literature. It's one of the first places you'll see that. So I do like to. It's kind of morbid. I'm going up and I'm grabbing for a carotid pulse. I'm looking to see if they're breathing, and I'm taking their jaw and I'm moving it up and down, kind of like a talking motion to see if it's stiff. If it's stiff, they have rigor mortis, and I'm not going to do CPR. So this last slide is basically talking about a medical examiner. Medical examiners are usually physicians or crime scene investigators or both that'll come out to a scene, especially in suspicious deaths. So if someone dies at a scene, or it's an unknown cause of death, or a suicide, or a homicide, or some type of violent death, or motor vehicle collision, or suspicious death, or some type of poisoning overdose, or a child dies, they'll come out and do an investigation with why did this patient die. Where you don't see medical examiners is in like hospice or nursing homes, or usually even hospitals. But hospice, nursing homes, you won't see a medical examiner. Okay, they don't come out. One of the last slides, organ donors. just keep in mind that this varies state to state. Like in Texas, we have a little thing on the car that says, yes, you're going to be an organ donor. You sign that when you get your driver's license. Um, but basically, I want to stress this, that saving a patient's life is priority. And I've been working in EMS for almost a decade now, and never once have I looked in a patient's wallet or asked myself, should I treat them based on the fact if they're an organ donor or not? Don't care. Not my problem, right? Not my interest, I should say. I treat patients all the same, right? It's not really a paramedic or EMT's interest if they're an organ donor or not. We treat patients. That's what we do. Hospitals harvest organs, not us. So just be aware of that. Your treatment really doesn't change a whole lot or not if they're an organ donor. You don't really go looking for that. Okay. Um, Last thing, sometimes we have these things called medical bracelets, and they in Texas they're not valid for DNRs. So I'll give you an example. Just because someone has a DNR bracelet doesn't mean that you're not going to do resuscitation in Texas, at least. Like in Texas, they could have a DNR bracelet, that's their business, but they have to have a valid paper DNR form presented to you. The bracelet doesn't really mean anything. It might clue you in to say, oh, I see a DNR bracelet. Who has the DNR? Oh, you have the DNR. Can I see it? I look at the DNR. Yep, they have a valid DNR order. Cease resuscitation. We're no longer going to resuscitate. There might be some value in that. But where you see medical bracelets more often is like medical alerts, right? Like type 1 diabetic, type 2 diabetic, or allergic to penicillin, or extremely allergic to peanuts or something like that. That's where you'll see that occasionally. Or severe epileptic or something like that. So that's where you'll see medical bracelets. You don't see this a whole lot, but you do see these occasionally. And I know a guy that has a guy I used to work with who's actually a paramedic. That used to he had a type 2 diabetic tattoo that looked like bracelet, looked like a bracelet. It said like type 2 diabetic on it real big. So I thought that was kind of cool. But yeah. Um, that's the last slide. I appreciate y'all's attention. If you have any questions, you can, as always, email us at reach out to your instructor or email us at education@pchdtx.org. Appreciate your attention.